We've been talking about the Children Act for a while. We want to continue talking about the Children Act because it has been reenacted. Imeongezwa vitu zingine mbaya zimetolewa. Now it's a new, fresh, better justice piece of law, the Children Act 2022. Our guests this morning are two ladies. One is Roselyn Kabata, Head of Department Access to Justice for Vulnerable Groups at the National Council on the Administration of Justice. And the other one is Juliet Gachanja. She is a child justice expert. She's an advocate at the High Court of Kenya. Ladies, good morning.
Good morning.
Thank you very much for joining us. Welcome to Kenya's biggest conversation.
Thank you for having us.
This is the hot seat of the Situation Room.
These are the hot seats.
Kila kiti ulichokalia. Karibuni sana.
Asante.
Juliet,
Yes.
you're a child justice expert. What's that?
Well, I would like to say I'm an expert because people call me an expert. But it's also out of many years of working around children issues. So currently I'm advising the Office of the Chief Justice on issues of child rights and child justice issues. And I think this is where the name came from. It's just out of working for, about 18 years on issues of child rights. Yeah.
Yes, you're an expert. 18 years, issues of child rights?
Yes, specifically.
Okay.
18.
You're a card-carrying expert.
Now, why I'm asking if it's 18, if I, looking at her, I thought she left college maximum 5 years ago.
Thank you. I'll take the compliment.
You saw that coming, didn't you?
I saw him from far. I knew.
From the halfway line. Not even 18. Halfway line. Roselyn,
Yes.
at the National Council on the Administration of Justice, you said there's a department called Access to Justice for Vulnerable Groups. Okay, what does that department do?
So thank you first for having us. We are very happy to be here, SpiceFM. I think you've been such a great advocate for the Children Act, especially upon its repealing. So the Access to Justice for Vulnerable Groups was a department that was created this year following the passing of our strategic plan, the National Council on the Administration of Justice Strategic Plan. And that's one of the outputs for the NCAJ, Access to Justice for Vulnerable Groups. And under that department, there are two committees. That's the Committee to Review Laws on Sexual and Gender-Based Violence. And then there's the Standing Committee on the Administration of Justice for Children in Kenya. So the work of that department is to ensure that the issues to do with vulnerable groups are raised and addressed. Yes.
Okay. So there's many times that we've talked about children and the law, right? We talk about when children then have to be taken through the justice system for one reason or the other. When they're taken to court and how they're treated, how then they are moved from one stage to the next. Does the new law revise things that were there in the previous law, or do new procedures also change how children are now to be taken through the system?
Well, yeah.
Okay.
Start with the expert.
We're both experts. Yes, but the Children's Act, what the Children Act 2022 does, essentially, is that it starts to consider the child from the point of view from where they are at home. And I think this is what is really interesting about this new law. So the previous one talked mostly about welfare issues. Didn't consider children who were the children in conflict with the law, the rules with how to deal with them, that came in the rules afterwards and not before. So this is what is important with this current act that we have, is that the children, we are looking at them as children first, and then now, sort of looking at the welfare issues, looking at children in conflict with the law, thinking about children who are accompanying their mothers to prison, thinking about children who are lost, which we refer to as children in need of care and protection. So there are various facets of children, but first we are saying they are children. they are children, and so long as you're below the age of 18, you're a child, and therefore there are various safeguards that you're entitled to as a child. Yeah.
When we're talking about these safeguards, and I think as maybe it's upon that which the premise for many of these, these other things are built. The assumption is that these safeguards then are only put up within the confines of a home, the nuclear family, father, mother, child. But then from clearly what we've seen when it comes to the abuse of children, unfortunately, the abuse of their rights, the inability to go to school, it's much wider than that. So in which areas are we seeing that we're asking for these safeguards to not only be set up, but then entrenched?
Well, I think, first of all, maybe going back to the first question, the Children Act has not really changed the agencies that are going to be dealing with children, but I think the highlights have been, the highlights on how children should be treated have also changed. Like there's the introduction of alternative dispute resolution mechanisms. So to ensure that the children don't enter the justice system, because the first point of contact is the police. Then after that, of course, they are handled by a children officer who's supposed to take into account their welfare issues and safeguarding. Then that's when we find the Law Society of Kenya coming in and legal representation. Then the judiciary is also involved, probation. And after that, if the child, of course, is culpable or not, or whether it's a child victim or a witness, then you'll see the Kenya Prison Service or the probation and aftercare services come in. So in terms of the safeguarding issues, I think there's a lot that has been done to ensure that these alternative dispute resolution mechanisms coming into play from the beginning, from when the child is seen as in contact with the law. And that's where you see that the justice sector is really insisting that children should not be held in institutions, because it has been shown that children do not thrive in institutions, and especially in terms of their development as children, to grow into adults. It's safer and a more nurturing environment if children can be in the family and in the community. And that's why the Children Act has now said that institutionalization of children shall be a matter of last resort. So the safeguarding issues have been taken into account by introducing or emphasizing on alternative family care and alternative dispute resolution mechanisms. So I think that's how the safeguarding issues have been brought into account in the justice system for children.
If I look at the executive summary of this document that you've given us, status report on children in the justice system in Kenya, there is a 7-point call to action. Okay, you've mentioned one. In this summary, it's number 5. Okay.
Yes.
What about the others? Because if I look at what is stated in the second point, they said establishment of a standing committee on child justice policy implementation and quality control by NCAJ within a 3-year reporting mandate to ensure implementation of the recommendation of the Task Force on Children Matters. Now, this comes after, number 1, immediate enactment of the Children's Bill 2018. So, how immediate is this?
It's in law.
Yeah.
Yes. Enactment.
Yes.
Yes.
Yeah.
But now, the action.
So I think, the report that you're reading now is the status report on children in the justice system in Kenya.
Yes.
That was done in 2019.
Yes.
A very a good report that was launched by the Honorable Chief Justice, Lady
Yes.
Justice Martha Koome, who was then the chairperson of the Special Task Force on Children Matters. And the report came about because there were a lot of challenges and so many issues in the justice system with regards to how children are treated, with regards to legislative and policy reforms, with regards to infrastructure, data, the quality of care, coordination and sensitization of the justice actors, so many issues, and we did not have a document that was putting the compartmentalizing that, all those issues. And the status report brought into account 7, we call them the big 7 recommendations. So the government had the big, is it the big 4?
Yes,
Yeah?
before.
So we had the big 7 in the justice sector for children. And the first one was that we realized was very important because you need according to the Judicature Act, Section 3, we have the laws that come into play. The first one is the Constitution. That's the law that is the backbone of our country. And then number 2, we have the statutes. Those are the acts and regulations and rules. And then number 3, we have customary laws, which are not repugnant to justice and morality. So we noticed and we were aware of the fact that if we do not pass the Children Act, we will not have a basis to have the reforms that we need. And that's why the first Big 7 recommendation is passing or repealing of the Children Act 2001. And that's why we have now the Children Act 2022, which, of course, the justice sector through NCAJ, the National Council for Children's Services, and the Directorate of Children's Services, and other partners, state and non-state, really pushed for this act to pass because of that reason. So number 1 was repealing of the Children Act immediately, because that is the foundation of reforms in the children's sector. The number 2 was having in place a committee to ensure that there's monitoring and evaluation of the progress in the child justice sector, and that has been done. We now have in place a standing committee on the administration of justice for children in Kenya that is chaired by the Honorable Lady Justice Teresia Matheka, who is a judge of the High Court in Nakuru. And through this standing committee, we have various state and non-state actors who sit together to identify the issues and challenges and solutions for the child in the justice sector. So those are the 2. The other 3, I think there's one on education for children in remand homes.
Yes.
There's one on alternative dispute resolution mechanisms, which I've touched on. There's one to ensure that there's coordination within the public and private sector with regards to children. The other one, I have to check, but I think those are...
The adoption of annual service month for
great.
children matters.
Yes, I think...
Service in week protocols.
Yes.
Yeah. Maybe a little bit of a background. So this report comes out of the work of the Task Force on Children Matters, which was established by the Chief Justice Emeritus, Professor Mutunga. And he's the one who established the Task Force on Children Matters, which was given 16 mandates, which were essentially around policy and legislative advocacy and formulation, which we realized instead of passing piecemeal legislation, let's just have the Children Act. Mm-hmm. Now, beyond that, there were various other recommendations that we made from that task force. And that is why we said, well, to actually implement those recommendations, then let's establish the standing committee. But this year, instead of just establishing a standing committee to implement the recommendations, the Chief Justice, Honorable Chief Justice said, well, beyond just looking at the recommendations, how's about the standing committee? Because children make 51% of the Kenyan population. They are not a moving target. We have children forever. So we're going to have a standing committee that is going to actually mirror the work of the NCAJ, so that our work is also policy formulation, it is coordination, to ensure that the work of children within the justice system, within the justice sector continues, and coordinate the justice system to ensure that children are protected all through. So one of the wonderful things that we're also celebrating this month, November is really the month for children. And on 20th, we observed the World Day of Universal Day of Children. And this month as well, the Honorable Chief Justice launched the Service Month. So November is the Judicial Service Month for children, where the court is expected to take lead in enforcing the rights of children, creating awareness, sensitizing the public on the rights of children. And indeed, the rallying call for this month is the Children Act, a new dawn for children, and the opportunities that it brings. So this is why I think I can confidently say that within the first year of, this was past, the report is a 2019 report, but I can say in 2022 we have seen the achievement of quite a lot of those recommendations that we made, but there is work to be done, because this is really just the beginning.
Now it's the implementation of all these recommendations and all of them. Coming back to the word I was looking for earlier is conflict. Children in conflict with the law, right? That's how you describe it.
Yes.
So these children were in conflict with the law. One of the things that you're saying is the push is to avoid as much as possible institutionalization of these children, right?
Yeah.
So what are these institutions where these children are taken to presently that we want to avoid? What are they? Is it Boston institutions, remand homes? Tell us all those institutions.
Yeah, maybe I can just try and take us through the institutions that exist for children. So one, we have institutions and we have facilities. So when a child is in conflict with the law, it means that they have gone against a law that requires for them to go to court, right? That has a punishment. And in Kenya, right now, we've because of repealing of the Children Act, we've raised the age of criminal responsibility. So a child in conflict with the law is defined as any child who's below the age of, above the age of 12 and below the age of 18 who has committed an offense. And when a child commits an offense, of course, the first point of contact is the community who might bring forth that report to the police. So that's the police station. And we find that the police station has facilities for mostly it's not for children.
For people
it's
who
for
are in
adults.
conflict with the law.
Yes, for people who are in conflict with the law. And the Children Act has introduced child protection units, which the Inspector General is supposed to make sure that each police station has a child protection unit. However,
A child protection unit, that is a cell for children.
yes,
Okay.
it's a temporary facility to make sure that the child is held there before they are taken, of course, to court.
The cells are all temporary. So it's a cell for children.
It's
Okay.
a cell for children, but it's child-friendly, child-friendly cell. So that's a facility for a child. That's the first one, child protection unit. Then when a child goes to court and they take plea or not, maybe they don't take plea, they are taken to the remand home.
Yeah.
And the remand home is where they're held before their case is concluded. And that's where there's such a sad state because some of these children stay there for too long. We've met children who stayed there for more than a year, more than 2 years.
How many remand homes do we have in this country?
Yeah, we'll have to confirm that. All I know is that they're not enough,
Yeah,
but we
they're
shouldn't be going for enough.
So they're crowded.
We shouldn't have remand homes.
I think then the question is, if we know that there will be children who are in conflict with the law between the ages of 12 and 18, what then is the recommendation? What are we looking at then in terms of, restitution, rehabilitation, things like this? Because the truth of the matter is, as innocent as children are, and that is, I think, the pre-assumed notion, isn't it? Because they've not had that much in terms of experience on this earth. All right, something may have gone amiss. If there's going to be restitution and rehabilitation, the first thought was the Boston homes, the remand, the juvenile centers which exist. So what are we saying needs to happen for these children? Because we'll also find, just from some other research that I looked at, a lot of the children who end up in these homes in the first place are the result of broken homes. They didn't get a good start in life anyway, and they were almost preconditioned towards this life. So if we're saying that the hope is that they go into a nuclear family whereby they are rehabilitated, where are they? How are they going to be? Where's the restitution coming from?
Yeah, so children are not, they're not essentially and totally innocent, first of all. But the mind of a child is very easy. We talk about the mind of a child being like a sponge. So anything that is fed to it, it will attract. But science is also teaching us now that children actually until the age of 25, in fact, the brain until the age of 25 does not understand cause and consequence. And that is why we are insisting on this, on the developmental aspect and psychological aspect of looking at a child and the rights of the child. So that means up until we are able to really ascertain whether the child was able to understand the mistake they did and the consequences that follow. All of us on this table then are required by the law to ensure that we provide that safe and protective space for the child. But in the event that the child then goes in conflict with the law, we are supposed to be thinking of rehabilitation. And rehabilitation is it's not just saying, you've committed an offense and putting you away in a rehabilitation center, which is, learn your lesson. We are talking about treatment. We're talking about putting in place a treatment that actually will look at why the child offended in the first place. And therefore, the probation and aftercare department comes in very critically here. So once the child goes through the justice system, at some point, the probation officer will be required to make a report, a recommendation as to what the court should actually do. The second thing, after we have talked about rehabilitation, we also have to think about reintegration back into the society. That should be the aim, and that is the aim of this Children Act, really. And that is one of the turning points in this Children Act. We're not just saying the child is a subject, is in conflict with the law. We're saying, how do you reintegrate them into the society? That means that we have to go back to that family that Ndu talked about and said, this is where the breaking point is. So we're going back into the family and saying, what is that we can do together with the family so that we can address the issues that pushed this child into the crime in the first place. And this is, one of those things that we're actually working now on in the Office of the Chief Justice to see how do we craft a strategy where the judiciary is not just, sending off an order and saying, we have committed you to a rehabilitation center, but also the judiciary is saying, what can we do with the family? Because as you've rightfully put, research has also shown that family breakdown leads to neglect, leads to then children who are on their own, and therefore children who commit crimes or children who offend. Or, unfortunately, children who then become victims of abuse, right? So reintegration is a key part. And the Children Act, what it now provides for, which was not there in the previous act, is family conferencing. So where we sit together as a family and we ask ourselves, what is our responsibility when it comes to this child, and also how must we be held responsible and accountable towards reintegrating this child, because at the end of the day we have to bring this child back into the community, regardless of what they have done. But I think it is important for us to also admit that it doesn't mean that these children did not commit the offense. Sometimes I feel like that is where the community is just like, we don't want this child. I mean, what is she doing here? She stole. She's a thief.
She killed.
She killed. Yes, we have children who are actually committing murder, and we have their cases in court, and they're in the remand home. We have to admit that indeed the child has committed the offense, but what is important for us to be able to reintegrate the child is to say, what caused this in the first place?
I want practical cases.
Yes.
I want just practical case point. Let's take a break. When you come back, you tell us. So, you see, you've told us about a children's cell. I can visualize. These are things of now, instead of going to remand, let's do this and the other. I want to understand. So what is a practical proposal here?
This is the Situation Room, the only way to start your day.
The opportunities for the Kenyan child when it comes to justice. Roselyn, you were telling us about the journey that then this child should take with the new recommendations from the new law. So, number one, yes, you said child-friendly holding facilities at the police stations. And of course, that also goes into the court cells, right? Those basements. Yeah, there should be child-friendly things that are done there. Even human-friendly cells all over. Then, when the child is then going through this process of a hearing for a case, if we say we want to avoid them going into these crowded children remand homes, where else could they be taken?
Well, if a child is in the system and they would like, or either the advocate or the family or the system generally would like to ensure that the child is not held inside there in the institutions, there are several options for this child. And that's what I mentioned, the alternative dispute resolution mechanisms. The first one is diversion. Previously, it was done by the Office of the Director of Public Prosecutions. The New Children Act identifies that any authorized officer as defined in the Act, and the court itself can divert a child away from the justice system. And diversion means essentially that just making sure that they're turned away, that they do not stay in the system. And this is done, first of all, through a pretrial, the family group conferencing, where they identify if this child is eligible for diversion. Then the other option is plea bargaining. And plea bargaining is where the child, first of all, admits to committing the offense. They have to admit voluntarily that they committed the offense, and after that they will be given either a lesser sentence or even the case is dismissed most of the times. And of course this is it is offered by either the Director of Public Prosecutions, the DPP, the prosecutors, or the child through the advocate or paralegal can also maybe present that to the prosecutor so that they can enter into a plea bargaining agreement. So those two options are the two best options that we have seen in the justice sector to make sure that the child is not held in the institutions. Either way, then if the child has to stay, then they are given bail because maybe the case has not concluded, and most of the children are given free bail, so they don't have to pay anything. Yes, they don't have to pay anything to the court. So then that they are taken back to the community as the case proceeds.
So being taken back to the community is going back to their home.
Going back to the home, sometimes.
Where they've come from.
Yeah.
This is assuming that they've come from a home.
Yes.
And this is assuming that that home they've come from was not part of the problem that they brought about the situation that took them where they were in the first place.
And that is why the social inquiry by the Directorate of Children's Services, so that's a report done by the children officers, is very necessary when you're going to court. So the magistrate will always ask for a social inquiry report, or they will ask for a probation officer's report. Mostly the probation officer's report will identify the situation on the ground with regards to the community. Are they going to be able to accept the child back? So the justice system doesn't just release children. They make sure that the children are released in a community that is safe, and of course the family that has accepted the child and will take care of the child, and make sure that the child of course comes to court if they are allowed, if the case is still ongoing. So those two reports inform a decision whether the child should go back home or not, or have an alternative for them presented.
You know, the NCAJ was a wonderful, wonderful, wonderful creation.
Yes.
The task that the NCAJ has is daunting at the very least. Because wonderful ideas, hope they'll be implemented. Yes, we've discussed the issues of resources and how that limits all this. However, there's a bit I'm stuck on here, and that is the education bit. You see, as lawyers, do you think it is important for citizens of this country to start understanding aspects of the law that deal with their rights and their positions from an earlier age as possible, so that whether it is in the primary school curriculum, secondary school curriculum, or in whatever course one takes at the university or any institution, that some of these things are actually taught, so that people begin interacting with these things that have to do with their sovereignty at an early age, so that even when an issue arises and somebody has acted contrary to what the law dictates, they are not completely ignorant. Now, are they, the question now, the Kenyan National Institute of Curriculum Development, I'm certain you've had conversations with them.
Yes.
I'm sure you've had conversations with the universities. Have any actions been taken that ensures that such things are done? Because in my thinking, if that process isn't given priority, then everything else that may influence a child towards breaking the law is what will take center stage. And so when you introduce the law at a later stage, you will probably be fighting a losing battle.
Yeah, I think that's a very, very good question and a very good observation because the Ministry of Education is a very key ministry, I think that, of course, they're the ones who deal with most of the children. If ideally all the children go to school, then they're the ones who identify where the child is. They make sure that the child is educated, is knowledgeable in everything that they're supposed to. However, I think that has been a gap.
Are they members of the NCAJ?
They are members of some of the committees. We co-opt them. They're not a member in the council.
They ought to be.
Yeah, they should. Should be.
I think the problem is we see that sometimes when we talk about justice issues, a lot of times people tend to think about people who have conflicted the law. So, in other words, then you only have members who are dealing directly with the justice issues. What we have to keep remembering is that for children, and I mean for everyone else, is that the rights that are bestowed upon us under the Bill of Rights in the Constitution, they are for everybody. And therefore, try as not to compartmentalize institutions and organizations and agencies so that we don't include, for instance, the Ministry of Education or the Ministry of Health, and who also bring quite critical issues. But I also have to say that within the curriculum, children are taught actually their rights. They are taught. The question that teachers have always asked me, because I also train teachers to train children on the rights of the child, is, if you keep insisting that these are the rights of the child, then the child will one day say, hey, you can't do this against me. This is my right. I have my 6-year-old nephew who told the teacher, you cannot beat another child. It's against the Constitution. And the teacher was shocked, very shocked. They were like, what do you mean? And the child said, it is against the Constitution to beat up a child. So the teachers and the community has always had a problem with, so if these are the rights of the child, what if they carry a placard against me? In fact, when we were discussing...
That's a good thing if they do.
Yeah.
It means they've understood the concept and they're putting it into practice. But what if, the question is, are they also taught the consequences of not abiding by the dictates of this very Constitution?
Well,
because the two have to go hand in hand.
Yes.
You can't just understand the benefits of your rights and not understand the consequences that and the responsibilities that come with them. Yes.
I think one of the innovations that the Special Task Force on Children Matters has and rolled out last year in November is a magazine called My Day in Court magazine that was commissioned by the Honorable Chief Justice. And the magazine is supposed to sensitize children on what the justice system is. What are these words? Being guilty, not guilty. What does that mean? Who is a judge? What do you expect in court? What kind of questions are you going to be asked in court? What officers do you find in court? I think those are one of the innovations that have been there, and we are going to be circulating this even after the Child Justice Summit, which we will discuss a bit later. So that's one of the innovations that we have. And the question that you asked before, what has the NCAJ done to make sure that the children are being sensitized on their rights? We have Wakili wa Watoto clubs that have been...
Who represents children?
The legal practitioners, the lawyers, the students. We identified that one of the challenges we're having in the justice system is that we don't have legal representation for children. Lawyers, either we don't know if it's a lack of interest or it's because there's no money, it's not millions there.
Is it a specialty that is taught?
It's also an elective in the universities. So that is the other problem, is that children and the law, which I teach in Kabarak University, is an elective. So you have, out of 100 students, you will have 25 students who pick you. They pick the lecturer or they pick the class because it's either easy or not. So it's also an elective. And I also studied children and the law as an elective in the university. So that is one of the other challenges that you're having is that. And then it's also said that if you're a child rights lawyer, who will pay you? Children don't pay. Which is a reality, right? But the court is also at least trying to pay pro bono lawyers a little money just for representing children. But that is one of the other key gaps when it comes to our education system.
It's interesting that those who are in charge, those whose duty and mandate and practice and business is the law, have left this gap. I say this because it is the largest population of possible clients is in that group.
Yes.
And yet, this very key thing of representation, you have pediatricians, Doctors who take care of children, parents pay.
Yeah.
Because clearly the children don't pay. Okay.
It's a challenge.
For the legal,
It's a challenge.
for the legal part, though, we have to admit that, for medical, the parents will pay. For legal issues that children are facing, sometimes, and research has also shown, it's the family that are perpetrators. Unfortunately,
Doesn't mean they can't pay.
people who are close. It's true, and we can actually, under the constitution, enforce that. We can
Yes.
make sure that the state pays, because the state is the one that has a responsibility on children, and then the parents also have a responsibility within the constitution, within the Children Act, and all the other international laws. It's the parents and it's the state that have the responsibility. We can force them to pay, but can we also be alive to the fact that some of them come from very humble backgrounds,
Yeah.
and so they're not able to pay. And that is why, in my own thinking, then the state bears the ultimate responsibility when it comes to the rights of children and enforcing those rights, if we have our priorities right.
Regardless of whether the children are perpetrators or not.
Or not. That's what I'm saying, yeah.
Yeah.
Yes, if we have it right,
Yeah.
under the social assistance, social protection, under the Ministry of Labour now, social protection, if we actually get our ducks in a row, the first thing we should do is identify children who are actually vulnerable to crime. That means say that in conflict or to be victims. Once we're able to identify, because it's the push factor here is poverty. The push factor is lack of education. The push factor is access to medical health, and such like issues. So if we go back to the government that is responsible, according to the Constitution, for respecting and fulfilling and promoting the rights of everybody in this country, then if we identify those vulnerable people, which is what pushes them to the justice system, then we will not have to wait for advocates who are supposed to represent the children. We don't have to wait to fund the police, for instance, so that they can establish a police cell for children. We don't have to wait for the court to establish a children's court, for instance, if we get our ducks in a row. And there are countries that are doing that.
But
quite
the
honestly.
Constitution actually catered for this. If you look at the laws that you people work with as lawyers that relate to the office of the DPP, that was not the only office that was supposed to have been created.
Yeah,
Okay?
yeah.
There's a public defender. Now, we argue about all these things, and yet there is a provision within the law where you can actually do these very same things we're doing. No one removed it. It's just not funded, so it's
Yeah.
dead.
Yeah.
So, it isn't as though we are in a completely impossible situation. The avenues that we take seem to be the ones which seem comfortable, and there's this one which requires probably butting your heads with the government, because if we are pushing the agenda for children, I don't think we can allow any gaps, because whether we like it or not, these children will grow up. And the circumstances that we allow them to grow up in will impact on who they are. And this society and community that we talk about, it starts forming at a very early age. So now, if we have laws that enable us to do that, and then we are not doing anything to enact them, then really what are we doing? Beyond claiming that we are looking into the matters of children and trying to ensure that the lives and the rights of the children as enacted in our constitution are actually adhered to.
And in lieu, I don't want to say in lieu, but I can, to some extent, in lieu of the Public Defender's Office, then we have the National Legal Aid Service. Then they're supposed to give legal representation.
How does that one work?
They're supposed to give legal representation to everybody. So what we have, this is what is unique about children, and this is why I really am grateful for the Task Force on Children Matters that was established in 2016, is because we realized these gaps in institutions. Right? And so what we did is we brought on board everybody who could serve children, regardless of whether you have money or not. The question about resources, quite honestly, it's exhausting. But we have a little that we can actually put into use. And so therefore, one of the things we did is we empowered and brought on National Legal Aid Service, which was, I think, under the Office of the Attorney General. I'm not sure if it's still there. There's always questions about resourcing. But I can say that the National Legal Aid Service has really supported the task force, especially when we started what we call the service weeks. That means, going to court, training the courts, telling them this is what you do with children, then clear backlog. So we would always go with us. And this is a practice I'm hoping that can be, I don't know, entrenched. But it's something that when we went to train for instance, the court user committees, we would go with a lawyer from NLAS. So that they can join us in that, that entire week as we are representing children. So it's a practice, and this is what I think. I think it's a one child at a time kind of thing, because we also need to what is the word, budget, so that we can show that this actually works.
So now,
right?
There's a judiciary fund. You've talked about, all of these things come into looking at the vulnerable people in the society, the State Department for Social Protection. Does it have representation in the National Council on Administration of Justice? And should it? So that then they're able to sit in these conversations and know the role that they ought to play in also pushing for budgetary allocation for the vulnerable when it comes to justice.
So I think with that question, I think it's good for us to have a very broad picture of the justice system, because the justice sector is not just the judiciary. We have so many other actors in the justice sector that needs to be funded, because for us to have a coordinated justice system, all of us need to be resourced. So the judiciary needs to be resourced, the National Police Service needs resourcing, National Legal Aid Service, Directorate of Children's Services, the National Council for Children's Services, the Law Society. We need all the actors at the same level in terms of resourcing, so that the child, when they're passing through the justice sector in all points, they get the same quality of care or service, or the infrastructure is up to par or child friendly. So what the NCAJ, through the Standing Committee on Administration of Justice for Children in Kenya, has done, and with the support of UNICEF, we had a costing exercise. So that means checking the expenditures on what budgetary allocation has been made for children, and then what is the deficit. And then how much do we need to invest in the next 3 years, so that we can get an ideal child justice system that offers the quality of care the child needs, that is very well coordinated and has the proper infrastructure for children. So that is one of the reports that we will see launched next week. And it identifies the budgetary allocation that is needed to have an ideal child justice sector. So we need to fund everybody, not just the judiciary fund. So everybody needs to have some resources allocated for children. It's a very sad state of affairs, because most of the justice agencies do not allocate funds for children, even if they're handling children.
Yes.
So that's the situation now.
Big push that's needed on that front.
Yeah.
Ladies, we thank you very much for joining us today. And once again, the Child Justice Summit is taking place next week, 28th and 29th of November. Where can anybody attend?
So it's going to be live. It's broadcasted. It's going to be live. And the chief guest is going to be the Honorable Chief Justice of the Republic of Kenya. And we're expecting that the heads of the justice system will also be there, because there's a conversation that needs to be had on children in the justice sector. So we'll have commitments from the heads of the agencies in terms of implementation of the Children Act, because we know that the Children Act is not just paper. We need to get this.
We need to get it rolling.
Yeah, we need to get it rolling.
Thank you. Roselyn Kabata, Head of Department Access to Justice for Vulnerable Groups at the NCAJ, and Advocate Juliet Nyambura Gachanja, Child Justice Expert. Thank you very much for this conversation.
Thank you.